11:44 a.m., August 14th, 2024.
Nikki speaking. How may I help you today?
Yes, ma'am. I'm sorry. What was your name, please?
Nikki?
Hi, Nikki. My name is Reverend Dr. Andrew Winmouth, in the name of Lord Jesus Christ, and I am the victim of horrendous crimes, including crimes committed against me as a victim and witness to crime by Judge Karen Phipps. I filed a notice of appeal. However, additional documents I attempted to file in support of that, and in objection to Judge Phipps' most recent denial of my constitutional rights, and rights under federal code as well. I'm a crime victim, ma'am, and I need assistance. I shouldn't be. I have the state and the defense counsel trying to, opposing me, opposing me enforcing my rights as a crime victim. The rights being clear and indisputable. Is there someone there that can help me, please?
What's your case on?
I'm sorry. Well, that's the thing. I faxed over I filed a notice of appeal in the lower court yesterday, and that number is 21CR2358.
Hold on 1 second. I'm going to look it up for you.
Thank
I
you.
have to get over to my computer.
Yes, thank you very much, ma'am.
Give me a moment. I'm going to look up your case number
Sure.
for you and give you the case number. And then, are you trying to file more things on your case number or?
I did that. I did that earlier, and they were sent back, telling me I needed to include a case number on the documents. The thing is this: I am a crime victim. I should not have to file a thing pro se. I should have put my foot down and not done earlier. But my rights have been denied at every stage of this process, and I'm talking about constitutional rights. I'm talking about statutory rights. And moreover, Judge Phipps is guilty of felonies for violating those rights. I want Judge Phipps arrested, and the prosecutors.
Can you give me the case number again so I can look it up for you real quick?
Yeah, absolutely. It's 21CR2358.
Hold on 1 moment. You said 21CR2358?
21CR2358. Yes, ma'am.
Okay, it looks like your notice of appeal has been filed. So give me 1 moment. I'm going to go to a different screen.
Okay.
See what I can find for you.
Thank you. Thank you very much for your time and your assistance.
And what's your last name?
Winmouth, ma'am. WENMOTH.
Your first name?
Andrew.
Okay, so the case number you gave me is not your case, it's someone else's case and you're a witness on it?
I am the victim, ma'am. I was brutally stabbed, and then the prosecutor perjured herself by saying I wasn't cooperating. Judge Phipps has co-signed that, and I've got and documents just got rejected that I tried sending in that proved conclusively that it was perjury, and the court refuses to look at it. The prosecutors have blocked me for 3 years after getting brutally stabbed. The gentleman attempted my murder, and I've got voicemails proving that. That was his intent. The courts and the police department have allowed a gentleman to go unprosecuted for sexually assaulting me, for kidnapping me multiple times, for attempting my murder 4 or 5 times, and this is all verifiable by documents. This is outrageous, and it is clearly criminal. Uh, Judge Phipps is definitely obstructing justice, as are the other officers of the court, counsel.
And the problem you're having is you cannot file to the case.
No, the problem I'm having
I
is
can give you the appeal.
the problem I'm having, ma'am, is that I shouldn't have to file a thing pro se. I am a crime victim, and under the Ohio Constitution, I'm entitled to representation no less vigorous than the defendant, which means I get a lawyer appointed. I'm also entitled to an advocate. I've been denied that at every stage of this process, and that's criminal. It is absolutely criminal.
And that case is against William Irby?
Correct.
Okay, hold on. I'm going to get you someone to talk to. I just need to write this information down before I pass you on so they don't have to look up the information again. If you give me just one moment, I will.
(11:51 a.m.)
I'm so sorry. I don't know what happened with the phone call.
That's okay, ma'am. That's a prime example. If you read 2 Thessalonians 2, it'll tell you exactly what's going on with this whole fiasco. But it is absolutely a major, major problem.
I'm going to write down the information for the next person for you so they can look up your case.
That's fine.
If you just give me a few moments, I'll find somebody that can help you out.
Thank you very much, ma'am.
You're so welcome.
Hello, are you there?
I am, sir.
This is Doug Eaton.
I'm sorry. What was your name?
Doug Eaton, what can I do for you?
Yeah, hi, Doug. My name is Reverend Dr. Andrew D. Winmouth, in Jesus' name, and I am a victim of violent crime, including attempted murder, kidnapping, and sexual assault that occurred 3 years ago. Judge Karen Phipps has just yet again violated my constitutional and statutory rights, and she's actually committed felonies in so doing. She's been obstructing justice for 3 years. She has been violating every right I have as a crime victim, and she just thinks that she can do whatever the heck she wants, and that's criminal. It is absolutely criminal. As an officer of the court, sir, I'm reporting those crimes to you, and as a victim of these horrific crimes, I am asking for my constitutional rights, which includes
Can I stop you a minute?
Yeah, sure.
Because you grossly overestimate my position. As flattering as it is, I'm the wrong person to report this to. I have no authority over trial judges at all. And even my judges don't have any authority over trial judges outside of an appeal. So if you've got an issue with Judge Phipps, and it sounds like you do, and you may have a legitimate one, you need to file a disciplinary complaint with the Ohio Supreme Court.
Well, I've done that, Doug, and the thing is this: any citizen having knowledge that a felony is being committed, according to the Ohio Revised Code, has an obligation.
Well, hang on. I'm not unwilling to help you, but you filed a disciplinary complaint, and nothing came of it, and you think I have the authority to fix this?
I think as an officer of the court, you have an obligation to contact police and notify them that a crime is alleged to be committed. Actually, I know
I
you
don't
do.
have an obligation that a crime has been committed when somebody calls me on the phone and gives me very vague. You're wrong about that in these situations. If I witnessed the crime, that's true, probably. But if you filed a disciplinary complaint,
Yes, sir. Yes, sir. And they've been pending for
and what happened
months.
with that disciplinary? What happened with that disciplinary complaint?
Still pending. Still pending. Last as of yesterday. Um, what happened?
Well, I mean, I can't. Nobody's going to do anything with Judge Phipps while there's a disciplinary complaint against her pending. I mean, that's the process.
Well, if she's committed felonies, how could they not?
Well, they may figure that out. They may discipline or ultimately charge her. Okay, but you've got to wait for the process. I can't suddenly come out of nowhere and intervene in this process. I'm not trying to be difficult. But if you filed a disciplinary complaint, you've done you've taken the appropriate measures to bring this to the people who can resolve it. And that's the step you take. You just have to wait for it to percolate through the system. I understand it's frustrating.
Yeah, well, yeah, and it's been about 3 years, Doug, since I was brutally attacked, and I've got a guy out here that has stated an intent to murder me, and
So has he been arrested?
they let him out, Doug. They perjured themselves and let him out.
Okay, hang on. But understand, judges aren't omniscient. Okay? So when somebody perjures themselves, the judges are God, as you know, Reverend.
They sure aren't.
Okay, they are not all knowing. They are not all knowing. So when somebody comes into the court and perjures themselves, the judge may or may not know they're perjuring themselves. And occasionally judges make mistakes about truth. I mean, they have to on the fly judge the veracity of somebody and believe them or not. Okay? And judges are human and they're subject to mistakes. And they are asked to do this 1,000 times a day. Okay? And sometimes they get it wrong. And you may know that this guy perjured himself, but I'm sure Judge Phipps does not.
Well,
Okay?
she would have known had she called me in, had she afforded me an opportunity to be heard.
Well, that assumes she believes you. That assumes she believes you. In other words, I'm going to give you the classic case here that I always give in this analogy. There is an accident at a traffic light in the middle of nowhere in a backward Ohio county, one traffic light, two-way intersection, no witness. Both parties claim they have a green light. It goes to trial. The judge believes the wrong person. There's no way to fix that. Only God and the two people who told, the one person who told the truth and the other person who perjured themselves, and God know that that was a mistake. The judge makes a human mistake and believes the wrong person, and there are no witnesses. That cannot be fixed. It's a failing of the human system. The judge believed the wrong person. Not the judge's fault. Judges make mistakes. I make mistakes all the time. You got two people that testify, and the judge goes, I believe A, not B. And God goes, well, you got that one wrong. Sorry, Judge. But God doesn't have any way to communicate that to the judge until that judge meets him at the pearly gate. Okay? And if that's a legitimate mistake, I'd like to think the judge would say, well, you blew it there, Judge, but, I get it. So, understand. But I'm not trying to be unhelpful here, but if you filed a disciplinary complaint, are the charges still pending against the person who's attacked you?
No, no, Doug, and they absolutely refuse
So the
to,
charges were dismissed.
based on the perjury of the prosecutor. Yes, sir.
Okay, so let me make clear here. You're alleging not just that your alleged attacker perjured himself, but you're alleging that the prosecutor perjured himself.
Yes, sir.
And why would the prosecutor do that?
That's a great question, sir. Quite frankly, if you
It
read,
is a great question, isn't it?
if you
It
read,
is a great question.
I'll tell you where the answer is found, Doug, and it's 2 Thessalonians chapter 2. The individual that attempted my murder, who goes by the name of William Irby, he is absolutely the man of lawlessness and sin and son of destruction that is prophesied in 2 Thessalonians 2. And that book tells us that It's going to be.
Wait a minute, hang on a minute. Are you quoting the Bible now?
I sure am.
So you think I can figure out why the prosecutor? Okay, so let's go in a different direction here. As sympathetic as I am here, sir, there's nothing I can do for you. There's nothing I can do for you. You've got a disciplinary complaint against this guy. The charges that for whatever reason were dismissed, and there's nothing more I can do for you. I mean, you don't have an appeal pending.
I do, Doug.
Court administered.
I do have I do have an appeal pending. I filed a notice of appeal of Judge Phipps' order yesterday. The lady.
Do you know your case number?
Yes, sir. It's 21CR 2358.
Okay, that's the trial court case number. Hang on.
Correct.
Do you know your appellate case number?
No, sir, I do not.
That would have been helpful. Let me hang on. Because you're in the Court of Appeal. I want to be clear, so hang on a minute. And when you call in the future, start with your appellate number. But I'm gonna find it. Hang on a minute. I'm gonna try to find it. See if I can find it in the criminal system. What's the criminal number?
It's 21CR 2358.
They don't have the appellate number docketed yet. Hang on a minute. Hey, I'm on the phone. You tell Cindy to get it, 'cause I didn't usually do that. She tell her I'm on the phone with the pro se guy. I mean, I know what she wants, but are you William Irby?
No, sir. My name is Reverend Dr. Andrew D. Winmuth. In Jesus' name, I am the victim and witness to
Okay, I get it.
those
All I need
offenses.
is the name. I don't need the whole boilerplate afterwards. So hang on a minute. And you filed this notice of appeal yesterday?
Yes, sir.
Let me see if I can find the appeal. And what's your last name again?
Winmuth. W-E-N as in Nancy, M as in Mary, O-T-H.
Spell the last name one more time. I'm going to call the clerk.
W-E...
However, hang on a minute. Hang on. You're the victim. What is the defendant's name? 'Cause that's the case I need.
Irby.
That's the name of
E-R-B-Y.
Irby.
Yes.
Okay, I've got it. It's 498. I can't see the lower court judgment. Let me go back to the trial court document.
I'm sorry, what did you say the 10th District?
So I've got it. So are you appealing the 812 judgment? Are you appealing the 812 judgment?
Yes, yes.
Yes, so you're appealing the answer to deny your motion to enforce the victim's rights and vacate the dismissal. That is appealable, and this court will handle it in the normal court. And you do have an appeal. That is appealable.
Okay. Now, as the victim of these crimes, I'm asserting my rights, Doug, under Marcy's law and the Ohio Constitution.
Yeah, I understand. I understand that's what you're doing. Yes, I get that. Yep.
So, I guess what
And that's why you have a right to appeal. That's
right.
You've asserted your right by appealing.
So beyond the notice of appeal, there's nothing else that I need to do because
Well, you will. You will. So hang on. So what will happen here? Was there a hearing on this motion before the victim's right?
no,
Or
sir,
was it done all on paper?
no, sir. In violation of the law,
Okay,
there
I
is
get it,
not.
but no hearing. I don't need that. Just yes or no. There was no hearing. So you filed a motion and there was no hearing. It was done on your motion and denied. That's fine. So what will happen here is very quickly, in about the next 2 weeks, you will get a notice of transmission of the record, which means that the trial court documents come over. Once you've done that, you will have to file a brief. And you'll have 20 days by rule, actually, you'll have 15 days by rule, because you're on an accelerated calendar, to file that brief. However, we are liberal with extensions. If you need more time, you're going to have to submit a written brief to this court that lays out the assignments of error, why you're alleging how this was error. The state will have an opportunity to respond with a brief. And then this case will be scheduled for oral argument for a panel of judges, and then a decision will be issued. But you have an obligation to file a brief. To prosecute by filing a brief. And the brief has to be minimally compliant, but we can talk about that after the record is submitted. But you need to keep your eye on the notice, a mailed notice of transmission of the record, because that triggers your briefing time.
So, Doug, I understand all that. The thing is, as the victim of crime, I'm entitled by law to representation no less vigorous than that afforded to the defendant. I'm disabled because of these crimes, and it is the most disgusting thing in the world
So are you
that
seeking
more
appointment of
burden would be put
counsel?
on me.
Hang on. What are you asking? Are you seeking appointment of counsel?
Yes, sir. I need an advocate, and I need appointment of counsel to file this for me because
Well, you
there.
need to file a motion. You need to file a motion. You can't ask me over the phone.
Under the Americans with
File a
Disabilities,
motion.
Doug, under the Americans with Disabilities Act, I'm requesting the reasonable accommodation of my freaking constitutional rights. This is appalling.
And reasonable accommodation would be what reasonable accommodation are you requesting?
Someone to write this out for me. Someone to fill out this motion, because there's no way in heck that any more burden should be put on me as a victim.
I'm not sure that I don't think you can make an ADA request over the phone. Secondly, yeah, I'm not sure asking the court. In other words, I get it. Did they appoint counsel below? Did you request counsel below?
Sir, they did not give me an opportunity to be heard, so no.
No, I didn't ask you. Did you request counsel below?
I did not have an opportunity to be heard, Doug, and please don't disrespect me again, sir. I have a constitutional right to be treated with dignity at every stage of this process as well, sir.
And that cuts both ways. That cuts both ways.
It sure does. It sure does.
Yeah. So just so when you say you didn't have an operator, did you? I'm going to pull up your trial court form. So let me look at the trial court doc here. So you. When did you? Let me see here. So you. So you were able. So I assume the motion that was denied in the trial court is your notice of intent to arrest.
No.
Trying to figure out what motion the trial court was ruling on when they ruled on your motion, denied your motion to vacate. on July 15th. So hang on a minute. Okay, so 8 times 4. Okay, so Mr. Mr. Winworth, you filed a motion to enforce victim trust in the trial.
Yes.
You can clearly file a motion requesting appointment of counsel. And I'm going to ask you to do that. Because I cannot ask somebody in the court to act as your counsel. And based on the motion that you filed to enforce your victim's rights, you are clearly able to file a basic motion. Because you did it. So I need you to file a motion requesting appointment of counsel in the appellate number. In 24 AP 498. If you file in the trial court number, we'll never see it. So as quickly as you can, and there's no great rush, but file a motion requesting that counsel be appointed. I don't know what the court will do with it, but you do need to file a motion.
So Doug, Article 1, Section 10A of the Ohio Constitution says the purpose is to secure for victims justice and due process throughout the criminal and juvenile justice systems. A victim shall have the following rights, which shall be protected in a manner no less vigorous than the rights afforded to the accused.
I understand. I would ask a criminal defendant, who was filing a pro se appeal to file a motion for appointment of counsel.
The criminal defendant had a lawyer appointed, Doug.
I understand, and all I'm asking you to do is file a motion requesting appointment.
And I'm making that motion right now to you orally, sir.
You cannot make a motion to the court administrator on the phone. It doesn't work that way. I can't do that. The judges have to grant it. I can't grant it. You can't do it over the phone. There are no phone motions.
Well, Doug, I'm disabled and I'm a victim of crime. I'm disabled because of these crimes.
I'm not trying to be difficult. I'm trying to be helpful.
Well, you're not, Doug. You're not being helpful, sir, and you're violating my rights in not affording me my constitutional rights.
I'm not doing everything you want does not mean I'm not being helpful. Okay? I'm trying to be helpful, but I'm looking at a motion you wrote out and signed on July 15th in the trial court, which leads me to believe that you are able to write out basic motions. All I'm asking you to do is move for appointment of counsel if you need. I cannot draft the motion for appointment of counsel before you because I cannot serve as your lawyer. And no one employed by the court can do that.
Sir, I'm entitled by the law to an advocate and representation no less vigorous than the rights afforded to the accused.
I guess you may well be, but you cannot make a verbal request to me over the phone. I mean, I don't know how else to tell you this. I need a motion on the docket requesting the appointment of counsel. The court will then consider it and may well grant it.
It's on the docket, Doug, and I'll just, you know what, I'll record it by video, and I'll just post it on our organization's YouTube channel, along with
That's fine.
evidence.
That's fine. Where is it on the docket? Explain to me where it's on the docket.
This phone call right now, Doug, this is perfectly admissible evidence that my rights are being denied.
I'm not troubled by that. That's fine, and I'm not troubled by that, Mr. Winworth.
Good.
That's perfectly okay.
Good.
Okay? My question is you said you had already filed a motion for appointment of counsel, and it's on the docket. Where would I find that? Because I don't see it on the appellate docket.
Sir, in the lower court, I filed a motion to enforce my rights as a victim, and I should not have had to do that.
I guess I don't know where to go with this conversation. I really don't, Mr. Winworth. I told you how you can enforce your rights. I've explained that you can file a motion. I've pointed out that you were able to file a motion in the trial court. I don't understand why you're not. I don't know what else to tell you. I've explained to you how to proceed. I don't know how else to tell you. I can't. I am not your counsel, and I can't service your counsel, and I'm doing everything I can here to be helpful. But at a minimum, you need to file a motion for appointment of counsel. And I'm looking at a motion that you appears to have done in trial court just a few days ago.
And due to the injury caused by the trial court, by the trial court's horrendous actions, I am now further traumatized and injured to the point that I don't feel capable of. I shouldn't have to, but I don't feel capable of representing myself.
I'm not asking you to represent yourself. I'm asking you to file a motion for appointment of counsel.
Is that a crime victim's job, Doug?
I'm sorry, what?
Is that a crime victim's job? When someone is brutally attacked, is it their role in the court system?
You do have to litigate your appeal. So I don't know that it's your job, but if you file a victim's rights appeal, you do have to prosecute the appeal in the same way anybody else would have to prosecute the appeal. I'm not really trying to be difficult here, Mr. Winworth. I'm trying to do what I can to be helpful. But you can't simply file the appeal and walk away from it. You've got to prosecute.
Oh, I'm not walking. I'm not walking away from it by any means. I'm taking it head on because the defendant has counsel appointed, and he doesn't have to lift a finger in this process. There's no way in heck I should have to.
Well, as I've explained, if an indigent prisoner came up here and wanted counsel for purposes of appeal because the trial court didn't appoint him, we would ask him to file a motion for appointment of counsel. It's done all the time. And if it was a direct appeal, we would grant that appointment. And I'm asking you to do the same thing here.
Can I file by email?
And I think,
Can I file by email, Doug?
I'm sorry, what?
Can I just send a written?
I can't, hang on. Say again?
Can I request a reasonable accommodation of sending an email, simply requesting counsel be appointed?
Yes, if you send an email to me, I will file it as a motion.
Perfect. That we can agree on.
Although I will concede that if you're able to write out an email, it's not clear to me why you're not able to write out a motion and file it. Do you have an e-filing account?
Yes.
It looks like your last motion was filed electronically.
Yeah, I do, Doug, and I just tried filing documents, and they were rejected. Improperly.
In the appeal?
In the lower court case, because the appeal hasn't. I don't have a. I didn't have a case number, or I don't see the case number in my e-filing account.
Do you have the case number now? Because I can give it to you. I've got it in front of me.
Yes, if you give it to me, that'd be great, sir.
It's 24 AP 498.
I'm sorry, 24.
24 AP for appeal. 24 AP
Okay.
498.
AP 498. Okay, I've got that, sir. And what is your email address,
And
Doug?
in your email, okay, hang on a minute. In your email, you're going to have to both request a reasonable accommodation and indicate why you need that, and ask that we treat the email as your motion for appointment of counsel, which is actually more than you would have to do if you simply filed a motion, just to be clear. Because if you just file a motion, you won't have to make the accommodation request. So that's your call. But if you want to make an accommodation request, do it by email, and then also request in the motion. So the email's got to include your request for accommodation with an explanation of why you need the accommodation, and a motion for, and ask that we treat the email as a motion for appointment of counsel, and then request counsel in that email. If you would prefer to do this in e-files directly into the appeal, all I need is a motion for appointment of counsel.
Okay, sir. What is your email address, Doug?
It's DWEATON at Franklin County, Ohio, all one word, .gov.
Okay, DWEATON at FranklinCountyOhio.gov, correct?
Yes, and I am assuming from your request for the email address that you're going to do this the more difficult way rather than the easy way, which would be the e-file motion, correct?
Yes, sir. I just sent you the email. If you confirm that you got that, I would appreciate that very much.
I haven't gotten it yet. I don't have it yet. As I indicated, I also need an explanation why you need a reasonable. I got your email, but that email is not sufficient. Because without an explanation of why you need a reasonable accommodation, I will not treat that email as a motion. I need an explanation. I need a request for accommodation under the Americans with Disabilities Act, and I need an explanation of how you're disabled so we can determine whether to grant that reasonable accommodation. My guess is that we will. But that email you just sent me is not adequate, which is why I'm telling you that email would be adequate if it was put into a motion format and e-filed in the appellate. That would be adequate as an appointment of counselor. It is not adequate as an ADA accommodation email because it doesn't tell me anything about why you need the accommodation.
So I said, as a disabled victim of crime, I'm requesting.
Yes, right.
I request appointment of counsel.
I understand that.
You understand that? You understand that I'm disabled, and you understand that I'm a victim of crime, correct?
I don't understand that you're disabled. That's the problem. Okay? If a blind person called up and said, I need somebody to read these to me, I would expect them to say I'm sight impaired. If a hearing impaired person called up and said, I need special hearing accommodations, I would expect them to say I'm hearing impaired. Just saying you're disabled, particularly given that you filed motions in the trial court on your own hand, is not adequate for me to accept an email motion from you without some explanation as to why you can't otherwise file a motion. You need to explain to me why this court should allow you to send me an email and have me walk it to the clerk as a motion, and that you're unable to do that. Because I'm looking at motions on the trial court docket that you have filed in the last month. And we will probably grant this. I want to be clear. I will probably allow this. But I can't, that email is not sufficient. Simply saying I'm disabled is not adequate. Because I'm looking at motions that you filed in the last 30 days.
Well, Doug, first of all, you're assuming that I filed those under my own hand. I did not tell you. I did not say that at all.
Did you not? Did you not? Because I've been saying that for the last 20 minutes. So somebody else filed those for you?
Doug, I'm a crime victim, and I am not going to subject myself to any further interrogation or questioning from the administrator rather than a judge. Doug, you have an obligation. You have an obligation under the law to file that. If you don't, sir, never mind. Not if you don't, sir. You are in violation of the law, hindering a crime victim in asserting his rights, and you, sir, under the Ohio Revised Code, are under arrest. It is 12:23 p.m., 8/14/2024. Doug Eaton at the Ohio 10th District Court of Appeals. He obviously disconnected the call. I did not. In Jesus' name, Reverend Dr. Andrew D. Winmuth. Again, it's 12:24 p.m. on August 14th, 2024.